Hi folks, I'm James Harrison, Director of the Institute of Employment Rights. Welcome to the fourth episode of our new podcast. Thanks to Thompson's Solicitors for sponsoring the podcast. Please visit thompsons.law/employment-bill to find out more from their team of employment law experts on the government's Employment Rights Bill. In this third episode of the IER podcast, our labour law experts, Professor Keith Ewing of King's College London, the IER's president, and Professor Nicola Countouris of University College London, one of the vice presidents of the IER, will share their analysis of the Labour Party's Employment Rights Bill. We'll be discussing what's in the bill and how elements of it might be useful for improving workers' rights. However, some commentators have referred to the bill as a Swiss cheese bill, so we'll take a level-headed look at where some of the gaps might be in terms of rebalancing the world of work and undoing the damage that successive governments have done to workers' rights over the last 44 years. Now, Keith, Nicola, the bill is very large, and I'm conscious we'd be hard-pressed to cover it all in this one session. And also, there'll be further episodes on other topics of the bill. So I thought we'd focus in on some of the key themes. The first thing that I thought we might touch on was there was a rush to legislate within the first 100 days of office here, but now it's become clear that there'll be no new rights until 2026. What's the situation here? What's the main provisions of the bill and what areas are not covered as a brief overview?
What I would say initially is that I think we need to look at some of the problems which the bill seeks to address or should be addressing. And I think when Labour came into government, I would say so far as employment rights are concerned, there are probably about 5 urgent questions. The first was the fact a lot of people were excluded from any protection of employment rights because of their so-called employment status. Second problem was low pay, poor conditions, rising inequality. Third problem was insecure jobs, this issue of 0 hours contracts, but also the problem of fire and rehire, which we saw most vividly at the P&O case in 2022. Fourthly, there's a problem of very weak remedies for people whose employment rights are violated. I think it urgently needs to be addressed. And fifthly, the question of weak trade unionism at the moment. Historically, trade union membership is very low, and the level of collective bargaining coverage is historically very low. And for me, I would judge the success of the bill by how it deals with these 5 core problems.
Nicola, would you like to add anything to that?
Yes, so I think this is a bill that had to be passed within the first 100 days of government. So inevitably, in order to make that deadline, which was an important deadline because it had to focus people's minds, there are some holes, as you said. Some things were left out. I don't think the bill purports to implement the entirety of Labour's plan for labour rights. There's more to come in the future, I'm sure. And of course, there are a lot of gaps within the bill by design. A lot of the detail is left to the consultations, but also to the statutory instruments that will have to be adopted in order to implement the bill. So there's certainly more work to be done around the bill and following the bill.
I thought we'd look at how are workers protected by this bill. Let's have a look at some examples. So one that we've probably spoken about quite a bit has been these day one rights. There appears to have been some political confusion around day one rights and a new initial period or statutory probation period. So are these day one rights, or will they effectively be, say, 9-month rights when the statutory probation period ends? So what do we think about that, the day one rights element of it?
First, I think we need to identify what we mean by day one rights. The answer to that, I think, is that employment rights should begin from the moment you start work with a particular employer. So in a sense, you're immediately covered by the framework of labour law. And there is some provision in the bill for making sure that where that principle does not apply, that it will be extended to particular categories of rights. So parental leave, paternity leave, issues relating to sick pay, but also unfair dismissal. Now, the issue of unfair dismissal has been the most controversial because, there are provisions now in the bill which provide that although it will be a day one right, there will be special provisions which will apply for what is likely to be the first 9 months of employment. And the bill will give to the Secretary of State the power to regulate the standards which the employer must comply with before a dismissal takes place within what will in effect be a statutory probation period of what looks like at the moment to be, as I said, 9 months. I'm not sure if Nicola has any points that he might want to add to that, but in general terms, that seems to be the framework. So day one for unfair dismissal, but diluted standards for dismissals that take place within that, what is likely to be a 9-month period.
That is very much a necessary reform. Day one rights, especially in the domain of unfair dismissal. Really, we have a very odd system, and it's quite unique compared to other legal systems around the world. Having a 2-year qualifying period for unfair dismissal, as we do at the moment, means that employers can unfairly dismiss you. They can dismiss you for whatever reason for the first 2 years of your service. And that makes no sense. And I think the bill tries to rectify that. But of course, it tries to recognize that employers may have to test your ability to perform in the job. And that's where the probation period comes in. That is the purpose of the probation period. And it should be structured very strictly and narrowly so that it focuses exclusively on delivering on that purpose, ensuring that the employer has recruited the right person for the job, rather than creating in practice a 9-month qualifying period for the protection against unfair dismissal. I think that's really the tension there with this possible dilution that Keith was talking about.
The question is why we need to have that probation period, because, even if you were to extend the law to from day one, the employer has adequate bandwidth within existing legislation to allow the employer to dismiss someone who wasn't suitable for the job, who committed misconduct, wasn't capable, or any other permitted reason for dismissal. There's already scope in the existing legislation, provided, of course, the employer went about it in a procedurally correct way. But, the standard that the employer would have to meet in the first few months, or maybe even the first 12 months of dismissal, is not likely to be very high. And I just don't see what purpose is to be served by this additional restriction, this 9-month probation period, when the employer already has the power to dismiss and to do so fairly.
Yeah, that's interesting, isn't it? Because prior to this, it would be internal procedures in an employment environment, but this has given it a statutory underpinning. So I'm wondering, how will this actually affect workers in the workplace? Because I assume contracts will have to be changed as a result of it, or maybe people who are just started at the point that it comes in, their contracts will have to be changed to take account of this, will they?
I'm not sure the contracts will have to be changed. This is a statutory protection which workers will have from day one. The employer, I think, may have to be a bit more careful than might otherwise have been the case. There will be guidance issued by bodies like ACAS to which both the employer and the employee will want to pay attention to. But the issue does arise in my mind, just how significant a change this will be, particularly for people in the early months of their employment, because it's somebody who's dismissed, say, after 3 months, they're going to bring a claim for unfair dismissal. You've got to think, what am I going to get out of this? What's the remedy going to be? And the reality is that for most people in that situation, the value of the claim will be exceeded by the cost of actually bringing the case. And I think it's important in principle that we recognise that people can bring these claims after day one. And as Nicola says, there will be cases where there are egregious mistreatments of employees for which this change will be welcome. But in the great majority of cases, I would have thought, even though the employer has acted unfairly, it is going to be highly unlikely that an employee is going to bring a claim because it's going to cost too much to get too little in return. So I would say my sense is that it's important, but let's not exaggerate the significance of the change.
Yeah, because it's an individual right. And if you've been only working for 3 months and you've been given the bullet, so to speak, you're not going to think about spending what money you've got on taking a tribunal that might come in maybe in a year or two and not knowing whether there'd be a satisfactory outcome for you, would you? Will these statutory probation periods be needed for short-term contracts? What happens if you've only got a 6-month contract?
There are 2 interesting points that this question raises. First of all, generally speaking, probation periods should not be too long, but they should also not be too short. They should be long enough to give a chance to the worker to prove themselves in the new job. Anyone that dismisses or terminates a contract after a 1-month probation period arguably hasn't given a fair chance to the worker to prove themselves. And that also addresses the second issue that your question raises. What happens with the thousands million of workers that work on very short-term contracts. And I think they should not be subject to the same probation periods. In fact, the probation periods should give them a certain degree of security in terms of having a chance to prove themselves to their employer over the fair amount of time to show their skills, their talent, their ability to perform in the job.
It seems that we should talk about worker status next, because obviously some people with varying statuses don't necessarily get the rights as they should now anyway, but they certainly won't have the new tranche of rights extended to them. I suppose a big concern that has been talked about with some of our experts has been tax breaks for the self-employed. One of my concerns was, could employers get around hikes in employer national insurance as well as the new tranche of rights by simply imposing self-employment contracts or other types of status onto workers through fire and rehire?
You're right, James. The more rights are attributed to workers and employees, the higher the national insurance contributions of employers become, the more there are incentives for employers to structure the contractual arrangements for engaging labour in a way that allows them to completely bypass these tax burdens. There's never been a more important moment, I think, to talk about employment status. And there isn't much in the bill, of course. We're told that there are proposals that will be made about a single worker status. That was a commitment in Labour's plan of May 2024. This is subject to a consultation. The consultation will probably take place in the early months of 2025, but it's a crucial policy for the rights contained in the bill to succeed.
At the moment, we have this odd situation in this country, which was actually created for what were largely benign reasons, but I think it has been to some extent counterproductive. In the sense, you've got three possible statuses. And one is that if you're an employee, you're entitled to the whole suite of employment rights, minimum wage, working time, unfair dismissal, redundancy, and all the rest of it. You've got this middle category of worker. And if you're a worker, then you're entitled to minimum wage and working time, paid holidays and so on, but not the other stuff. And then you've got this third category, this so-called independent contractor or self-employed person who's entitled to none of these and indeed to very little. Now, my sense is that the more rights that we give to employees, the first category, and the more expensive it comes because of the cost of national insurance, which employers have to pay in respect of employees, there will be even more pressure on the part of employers to find ways of engaging people to work for them, which take them outside of this legal status of employee. There is a risk here that unless we deal with the question of status, we're creating a trap door through which a lot of these new rights and a lot of existing rights will just collapse, because the employers will be looking for ways to engage people on a contract which is not a contract of employment. And the effect of that, of course, is that people will lose whatever rights the bill and other legislation may have created or may create in the future. So it is a problem that needs to be addressed, and it's a problem that has been recognised, has been examined now for a long time. It was a subject to investigation by the Taylor Review, which Theresa May set up way back in 2015, 2016. It's been a subject of intense academic and other discussion in the intervening periods. We now have a couple of private members' bills which address the question, one sponsored by John Hendy in the House of Lords, which basically promotes the idea that anybody who works for a living for another person should be protected by labour laws. And this reflects the principle that labour protection should be universal. It should not depend on some manufactured status which the employer has created to circumvent the employer's liabilities under the law. So this, I think, is one of the major weaknesses in the Employment Rights Bill, the fact that this matter has not been addressed. Now, as Nicola says, there's going to be a review, but who knows when this is going to take place? Who knows when it's going to be concluded? Who knows what the outcome of that review will be? Because employers will be arguing very hard to retain the status quo because it gives them the flexibility to move people from one status to another. And we will see, as time unfolds, the emergence of new forms of avoidance, which employers in collaboration with others, develop to ensure that these rights do not apply to the people for whom they're intended. And these people very often are the people who are the most vulnerable and the weakest members of our labour force.
Theoretically, if the governments do work towards a single status worker, it could have a massive impact, couldn't it, for people who are working for living under these different statuses. Without thinking about all the new tranche of rights, it would allow people access to justice who were already quite precarious employed. So theoretically, it could be a quick hit for the government, couldn't it, to do something like that, to give workers the boost that they need.
The most important thing it would do would be to give more people better job security, in the sense that it would protect them from unfair dismissal, protect them from unfair redundancy treatment. But I'd have thought the pressure on the government at the moment must be intense because, one of the major reforms in the budget was the increase in the employer's national insurance contribution. The government has presumably calculated an income from this increase, and it must be mindful of the risk that that won't happen if people are then moved from employment status to some other status, so that the employers in question will no longer be responsible to pay the higher national insurance contributions which the budget has required. So in the sense, there are two trapdoors here. There's a trapdoor in the tax system, which the government must be under some pressure to address. And there's a trapdoor in the Employment Rights Bill, which, again, you would have thought the trade unions would be keen to address on behalf of their members.
Nicola, what does Labour's plan mean when it says that we'll eventually transition towards a simpler two-part framework for employment status?
I think it means that at the moment we have this three-part status that Keith spoke about. The employees, the self-employed, and in the middle, this limby worker category that we understand Uber drivers, for instance, to be. And the idea is to move to a two-tier system where you have a much broader definition of worker, and then you have the self-employed. And I think this much broader definition of worker, we expect for it to make sense to at least include those who are currently classified as employees, those who are currently classified as limby workers. But I think we should also expect it to include some of those who are currently classified or misclassified as self-employed. And in reality, we don't just have a three-tier system of worker status in the UK, because employers can also source their labour through personal service companies, umbrella companies. So it's much more complicated than that. And these corporate structures, in reality, most of the times, simply hide a labourer with no capital, no tools, no clientele, somebody who, as Keith said, are exclusively making a living out of the labour, and they should attract all the protections that workers attract in the UK.
Yeah. Keith, is this important for trade unions as well as is for individual workers?
It is important because it's also, we've had a recent decision in the Supreme Court in a case involving Deliveroo, the food delivery company, where a union was seeking recognition for the purposes of collective bargaining on behalf of the riders who deliver food from the shops to people's homes. Under the legislation, you can only bring a claim on behalf of a group of workers, and the definition of worker is set out in the legislation. In this case, the Supreme Court held in its wisdom that the Deliveroo riders are not workers for the purposes of the legislation. So presumably the view is that they fall within this third category, that is to say they are self-employed people, which will strike many of us as quite strange that the riders would be categorised in that way. So it's not just individual employment rights that are affected by the right not to be unfairly dismissed, for example, but it's also fundamental trade union rights, the right to freedom of association, the right to engage in collective bargaining, which is also affected by this threefold categorisation. And it's another reason why we need to address this problem quite urgently. I mean, just right across the frontier of our labour law system, this is one of the urgent problems that needs fully to be resolved. And that's not to say it's going to be easy, because not only is there going to be employer resistance, which we know, but as time has gone on, and the longer we put up with this, there will be some workers who are not unhappy about this situation. For some people, to be categorised as a Limb B worker, it means that they enjoy the benefits of the minimum wage plus paid holidays, but they don't pay tax as employees. They're treated as self-employed for the purposes of taxation. And for some people, that's a trade-off that they're prepared to make. They may regard it as beneficial not to be taxed as employees and to lose as a result the right not to be unfairly dismissed. But the longer this goes on, the harder it's going to be to resolve this problem as people become more entrenched in their positions.
Nicola, this reform, it didn't make the 100 days cut. It's now subject to a consultation process. Do you know, firstly, why that was decided? And secondly, what are the pros and cons of this approach under things like zero contracts, fire and rehire, that kind of thing?
I don't know why it was decided, but presumably there's something about the complexity of the subject that pushed the government to think we need to consult with unions, employers, experts about this matter. So let's not put it into the first 100 days. But it does create a problem. I think from our discussion, it's quite clear that by avoiding the issue, the government has put the labour rights cart before the worker status definition horse. And that doesn't make sense because all of the rights that we're talking about, day one rights and protections for zero-hour contract workers, they only make sense if it's impossible or very difficult for employers to avoid these new protections by misclassifying the workforce as self-employed contractors. At the moment, that's a risk, and it's very easy. In the case of Deliveroo that Keith was mentioning, all they had to do was to put in a substitution clause that meant that just a small fraction of the workers, 1 or 2%, were using substitutes, and the whole workers missed out on trade union recognition rights. So it's very easy. We need a definition of worker that, as well as being broad, is sufficiently bulletproof to avoid this type of scheming on the part of unscrupulous employers, not all employers. The bill suffers a bit from a lack of direction in that sense. It refers to employees, workers, almost as interchangeable terms. They're not. Eventually, we have to get to a single word, a single definition. But it's not just a drafting problem. There's a substantive problem here. I agree with Keith, yeah.
Keith, can I ask what you think of the new legal framework being envisaged by the bill to address the problems of zero-hour contract workers face? I know we're going to be touching on this in a future episode, but I just wondered if you had any initial thoughts there.
Well, I got two thoughts. The first of these is that at the Institute, we drafted a bill for Unison about 10 years ago to deal with the problem of zero-hours contracts. What we were proposing at that time was that workers have a right to a minimum wage, which is calculated on an hourly basis. So the employer should be required to provide at the start of the contract a minimum number of hours which employees or workers are required to work. So in the sense that just like money is a commodity, so too is time. Or working time is a commodity for these purposes. And the employer should have to set out very clearly in the contract, at the time the contract is signed, what the working hours should be. And that doesn't deny any flexibility, but if you want people to work for more than the time sets out in the contract, then you pay overtime. People need certainty, they need predictability, they need clarity in their employment relationship, because it's from that they build all the other things around their lives. So it's not just pay, but we also need to know how long we're going to be paid for under the terms of the contract. What we've got in the government's bill is a tolerance of zero-hours contracts. So zero-hours contracts will continue to be permitted. What the employer must do is to offer regular hours after a particular period of time within which the person in question has been employed. So that's a good thing in the sense that you've got to receive an offer of hours based on the number of hours that you've worked within a particular reference period, working maybe 12 weeks back from the date the offer is made by the employer. Now, it's not stamping it out, but it's in a sense of encouraging employers to allow the worker to have a more regular contract. But there is a provision in the bill which says that although the employer is required to offer you regular hours based on the hours that you've worked in the recent past, it says quite clearly that the employee or the worker may accept or reject the offer. The worker is entitled to receive the offer, but the worker is also free to reject it. And so the concern which a lot of people have is that a lot of people will feel coerced into rejecting an offer, and this will simply be a formality, a process that has to be gone through, but to some extent, in some cases, very much a charade. So here I've got to offer you a regular contract, but my expectation is that life will continue as it is. The employer doesn't have to be too overt in the coercion which might be visited upon the employee. Now, what is interesting here is that you've got to make me the offer, James, of regular hours, but I'm free to accept or reject that offer. But there's no requirement here that when I make this decision that I've got to be advised, or there's somebody with me when this decision is made, that I have to consult my trade union, or the trade union should advise me, or that the trade union should be involved in some way. There's no protection or security for the employee at the time this decision is made or at the time the decision is conveyed to the employer. So I offer you a simple transaction done and dusted in the space of a few minutes. It doesn't go as far as we had proposed way back in 2014, which was basically to wipe out this practice and to put a duty on the employer to ensure that people knew what their working hours were and to stop treating people like commodities, which is basically what 0 hours does. I don't know, the government said they're going to ban exploitative 0 hours contracts. Question is whether this does enough to stop exploitation.
Do you have any additional thoughts on John Hendy's Status of Workers Bill that he did recently?
So, as Keith said, the major strength of that bill is the clarity that it brings to a new broad single status of worker by saying that if you're engaged by someone to provide your labour, you have to be considered a worker and attract all the rights that the labour law statute books offer to workers. If you leave off your labour, you're a worker and you have to be treated as such. But it's quite a sophisticated piece of legislation. So there's also a definition of employer because especially in the gig economy, you may well be a worker, but then there are questions about who's your real employer. And it creates actually a presumption of employer and employment that can be rebutted. It's a rebuttable presumption. These are all things that you see emerging in European statutes that regulate worker status, especially worker status in the gig economy, 0-hour contracts offered through platforms. And I think it provides a very sophisticated answer to the question, how are we going to shape this new single worker status?
Okay, I'm aware that we're probably running out of time. So how does the bill deal with pay and core terms and conditions? In our previous episode, Lydia Hayes, Professor of Labour Law at the University of Liverpool, talked about the government's plan to roll out sectoral collective bargaining in adult social care. But I wondered if you wanted to discuss here the importance of collective bargaining and sectoral collective bargaining more widely, comparing EU developments, both of you, and focus on the way that theoretically it could raise wages and reduce inequality in society as well.
Well, Lydia has already spoken about the importance of this bill, in particular for the adult care sector. Much more needs to be done even to assist that particular sector, but it's arguably a good start. But I think we need to see these provisions for these particular two sectors, support teaching is the other one, as an experiment that, if proven successful, should be rolled out to other sectors where the same problems that emerge in terms of underprotection, low pay, gender pay gaps, racial pay gaps that you find in the adult care sector are present. One of the missions of the Labour government is to make work pay, all work pay. And it's quite clear that the problems that you find in the care sector are not unique to that sector. They exist in several other sectors where pay has been stagnant, has fallen behind inflation for a decade now, where there aren't enough social actors, there isn't enough voice on the part of workers and the unions in order to achieve a good bargain for the workers in those sectors. So the way I see these provisions, they're interesting in and of themselves, but they are, and I believe that's what Labour's plan is, but a start into something that will be progressively rolled up out in this parliamentary term, I hope, if the conditions are right.
Okay, I think that's all the time that we have for this episode. Thanks to our expert speakers, Professor Keith Ewing and Professor Nicola Countouris, for sharing their knowledge and experience with us and for taking time out with their extraordinarily busy schedules to be part of this. If you would like to support this podcast, please consider subscribing to the podcast. The IER has an array of written and educational resources on our website, ier.org.uk. If you'd simply like to learn more, you can subscribe to our weekly newsletter at the website as well. Thanks again to Thomson Solicitors for their kind support for this podcast. Thanks also to you, the listeners, for being part of it. There's still lots to cover as we found today, so please join us for future episodes and be part of the debate.